It is very important for every corporate lawyer to have a thorough understanding of the law of agency. In fact, I'm always surprised that most of the company law textbooks on the market don't include, as standard, at least a chapter on the law of agency, since the law of agency, or how agency operates, is so important in company law. Think about it. A company can only act through its agents. A company, even though it is seen as a business or a company is seen as a person on its own, it's not a human being, it's not alive. So it cannot act without people working on behalf of that company, and those people are its agents. So a company, in order to act, needs to act through humans acting as agents. That's the only way in which a company can enter into contracts, etc. The main agents of any company is its directors. So you can see how it's very important to understand how agency works if we are going to look in detail at the relationship between companies and directors who act as agents of the company. One of the very important parts of any company law course is to understand the duties of directors. And when things go wrong, when directors breach these duties, who can be held liable? Imagine, for example, the situation where a third party deals with a director of a company, and the third party is under the understanding that through dealing with this director, in the end, this third party is dealing with the company. So the understanding is that, let's say, there will be a contract between the company and the third party. But let's just imagine that this director was acting in a way that he or she wasn't supposed to. Let's say that this director was acting outside of the scope of his authority. What then? Well, from the viewpoint of the third party would like the company to be held liable. From the viewpoint of the company probably would not like to be held liable. The company would probably say that, well, we didn't authorize this director to do what he did, so we shouldn't be held liable. It should be the director being held liable. So you see, the law of agency gives us an answer to that question. Who will be held liable? Will it be the director in his own personal capacity or in his capacity as an agent? And if he was acting as an agent, then it would be the company being held liable. So in order to understand properly the rules relating to directors' duties, we need to understand the rules relating to agents. And that brings us to the law of agency. I recommend that you go and at least read a chapter from this book, which I recommend, Ewan McIntyre's Business Law. Chapter 11 deals specifically with the law of agency. Now, what is an agency? What does it consist of? What is the relationship of agency? It can be seen as a tripartite relationship. There's always three parties. Tripartite means three parties. The principal, the agent, and the third party. So we can define an agency relationship as coming into being when a principal, I'll refer in these slides to the principal abbreviated as P. So the principal authorizes another person called the agent, I abbreviate that in these slides as A, to act on behalf of the principal. So one person authorizes another person to act on their behalf. The principal is the person who gives the permission. The agent is the person who receives permission to act on behalf of the principal. We can either have an agent for a specific matter, one particular matter, or we can have an agent for all matters. If the agent is there to act only for a specific particular matter, we call this a special agent. If the agent is there to act in a more general way, a general agent. Think about an estate agent. An estate agent is a very good example of a special agent. If I want to sell my house, I will authorize an estate agent to sell my house. And that is the only authority that he or she will have. They won't have any other authority to do anything else on my behalf, just this one thing. Contrast that to a director of a company or a partner and a partnership. The partner in a partnership will have the authority to do basically everything on behalf of the partnership, and a director will usually also have a very wide discretion to do a wide variety of things on behalf of the company. So the agent then goes out, negotiates with third parties, and in the end, those negotiations then lead to a relationship coming into being between the principal and the third party. Think of the estate agent. The estate agent will go out, find a third party who is willing to buy my house. In the end, the contract of sale, the sale of my house, will be between me, the principal, and the third party who wants to buy the house. So the agent then disappears. The agent has done his job, and the resultant contract would be between the principal and the third party. So that tripartite relationship can be visually represented as a triangle. The principal gives authority to the agent, and this can be very often in the form of contract. So you see once again why it is so important to have a very good understanding of the law of contract, because it permeates everything in company law. Agency starts with a contract between the principal and the agent. The agent then goes out and negotiates with third parties on behalf of the principal. If those negotiations are successful, this leads to a commercial contract, which would be a contract between the third party and the principal. The agent falls away. The agent is then not a party to that resultant commercial contract. So you'll see here we've got two contracts. We've got the original contract between the principal and the agent that gives the agent authority to act on behalf of the principal. And then we've got a second contract. If the agent did his job perfectly, this second contract will be a commercial contract between the principal and a third party. Now, we've already seen that agency is created through authority. This is where the principal gives authority to the agent to do certain things on behalf of the principal. We will be looking at authority in this lecture in quite a lot of detail, because this is the most important of the ways in which an agency is created. So we'll come back to that just now. The second way in which agency can be created is by ratification. Ratification is an ex post facto creation of authority. What does ex post facto mean? It means after the fact. It's in Latin, meaning after the fact. For example, let's say that my husband goes to a car boot sale, and while he's there, he sees a little statuette of Jabba the Hutt, a character from the Star Wars franchise, and he knows that I'm a Star Wars fan, and I collect all this memorabilia. I've got a collection of Han Solo and Luke Skywalker and all of the rest of them, and he knows that I quite like a Jabba the Hutt little statuette. So what he does is he buys this little statuette, let's say for £20, and he then comes back to me and he says, "Ooh, I acted on your behalf. I've got you this statuette. Please give me the £20. I acted as an agent." And I then say, "Husband, thank you very much." And I give him the £20. What I've just done is to ratify what he has done on my behalf. This means that when he was at the car boot sale, he didn't have the authority to act on my behalf. He did it of his own initiative, out of his own initiative. And afterwards, I then retrospectively gave him permission. That is ratification. Of course, ratification is not always sure. If he came back and I looked at the statuette and I said, "Are you insane? I don't want that. I'm not going to give you £20, then it means that he didn't have authority, he didn't get authority, and he would be minus £20. Now think about people who go out and act on behalf of somebody else, and that other person then says, no, you didn't have the authority to act on my behalf, who will then be held liable? Well, think of my husband. He will be down 20 pounds. And the same principle goes for people who act as agents without proper authority and where they don't get that authority afterwards. They will be held liable. They will be caught with the hot potato in their hands because the third party will then be holding them liable. We'll get to that as well. We'll look at what happens to agents who act without authority. The final way in which an agency is created is through operation of law. This is where there wasn't any explicit authority given, there wasn't ratification. It's just, as a matter of law, we see that these people always have authority to act on each other's behalf. We'll get to that. The only real way of in which this is currently recognized is spouses. But there are also other instances, such as, for example, when you act in an emergency, etc. But we'll get back to that. Let's first then look at authority, because this is the most important way in which an agent gets to act on behalf of a principal. Now, authority, firstly, is created with agreement. This is an agreement between the principal and the agent. So actual authority is when we have actual agreement. And actual authority could be either express or implied authority. Express authority is when it's said in so many, it's stated in so many words. Either it's written down in a contract or it's expressed orally. You know that a contract doesn't need to be written down. A contract can also be verbal. So we could have an express verbal or an expressly written down contract. But we could also have actual authority even if no words were uttered, either on paper or orally. So you can have an implied authority, implied actual authority by conduct. If you allow somebody to do something on your behalf and you say nothing about it, your conduct by condoning what is happening could still be seen as actual authority. So implied authority could be by conduct, but it could also be inferred from the circumstances of the case. So if something happens usually under a certain set of circumstances, then this could imply actual authority. An example would be things that partners usually do on behalf of a partnership could be seen as implied actual authority. However, authority could also be in existence or come into existence without agreement. Here we're specifically looking at something which we call apparent or ostensible estoppel, authority. This comes into existence by means of what we call estoppel, and I'll explain that to you in just a second. Ratification. We've just looked at what ratification is. It's the situation where a person doesn't have authority, he goes ahead and he does something on behalf of another person, and then afterwards that other person gives permission for what he has done. That is ratification. The principal ratified what has been done already on his behalf. And finally, the creation of authority by operation of law. This would be, for example, where you act out of necessity. You run into a burning building and you rescue people or things out of the burning building without the authority of the person who is the owner of the building. You were acting out of necessity. Under these circumstances, the law says that an agency situation has been created. Also, agency by cohabitation. This would be where a husband and a wife live together or two spouses live together, and you would then have the authority to act on behalf of the person you are cohabiting with. Now, getting back to authority, actual authority, let's look at this in a little bit more detail. Firstly, the one that we get the most, actual authority. Express actual authority, it's very easy. This is where it's written down, it's stated verbally, and everybody's sure this person is an agent of the other person. Implied authority is where It's not verbally expressed, or it's not necessarily put in writing, but it's implied. Let's look at a case as an example, the case of Healy Hutchinson versus Brayhead. The directors of company, in this case, allowed the company chairman to act as if he was the managing director of the company. Now, a chairman of the board is not necessarily a managing director. Those are two different positions in the company. But in this company, they allowed the chairman to act as if he was also the managing director of the company. In fact, this chairman had never been appointed managing director, and so he had no express authority to bind the company. The chairman then made a contract with a third party on the company's behalf. When the third party then wanted performance from the company said, well, hang on, the chairman didn't have the authority. He wasn't the managing director. He didn't have managing director authority. But the court said no. The chairman actually had implied actual authority to bind the company, and so the company was bound by the contract that the chairman had made. The court said that the company, by its conduct, had impliedly agreed with the chairman that he should have the same authority as if he had actually been appointed managing director. In this case, Lord Denning explained the difference between express actual authority and implied actual authority in the following way. Let me quote. Actual authority may be express or implied. It is express when it is given by express words, such as when a board of directors pass a resolution which authorizes two of their number to sign checks. It is implied when it is inferred from the conduct of the parties and the circumstances of the case, such as when the board of directors appoint one of their number to be managing director. They thereby impliedly authorize him to do all such things as fall within the usual scope of that office. Now, very closely related to this, to implied actual authority, is apparent authority. This is also known as authority by estoppel. And this comes into being when the principal creates an apparent situation or a picture, an apparent picture that is not quite the truth. So this is where the principal makes it or pretends that somebody is acting as their agent, but in actual fact, they are not. In such an instance, the principal will be held to the impression that he or she has created, namely that another person was acting as their agent. We say then that the principal is stopped from relying on the truth being that there is no agency. The principal will be stopped from relying on the truth and will be held to the impression that they had created. Let's explain this once again by looking at a case, the case of Freeman and Lockyer versus Buckhurst Park Properties Limited. In this case, the directors of a company allowed one of its directors, a Mr. Kapoor, to act as if he had been appointed managing director of the company. So very close to the situation that we had in Healy Hutchinson. Mr. Kapoor then engaged a firm of architects to act on the company's behalf. The company then later refused to pay the architects, arguing that Mr. Kapoor was not managing director and had no power to make contracts on the company's behalf. The Court of Appeal held that the company were bound by the contract because they had given the impression that Kapoor had the power to bind the company, and so the company was liable on the contract to the architects who had relied on this representation. Now, the two types of authority, implied actual authority and apparent authority, often overlap. And once again, Lord Denning explained in the case of Healy Hutchinson, which we looked at above, what the difference is. He said, ostensible or apparent authority is the authority of an agent as it appears to others. So we're asking, what do others think? If they look at the situation, what is it that others see? So Lord Denning further went on to say, it often coincides with actual authority. Thus, when the board appoint one of their number to be managing director, they invest him not only with implied actual authority, but also with his ostensible authority to do all such things as fall within the usual scope of that office. Other people who see him acting as managing director are entitled to assume that he has the usual authority of a managing director. But sometimes ostensible authority exceeds actual authority. For instance, when the board appoint the managing director, they may expressly limit his authority by saying he is not allowed to order goods worth than, let's say, more than £500 without the sanction of the board. In that case, his actual authority is subject to the £500 limitation. But his ostensible authority includes all the usual authority of a managing director. The company is bound by his ostensible authority in his dealings with those who do not know of the limitation. He may himself do the holding out or creating the impression. Thus, if he orders goods worth £1,000 and signs himself managing director for and on behalf of the company is bound to the other party who does not know of the £500 limitation. So this is a good way to remember it. Implied actual authority goes hand in hand with the usual authority of a specific position, whereas apparent authority goes beyond any internal limits that, for example, might have been placed on the usual authority that you have under implied authority. But it overlaps to a large extent. Apparent authority and implied authority. The point is, if you are the third party and you relied on the usual authority, what was made or what was represented to you as the authority of this person, you can go ahead and rely on that, and you can stop the principal from denying the truth, because you will not know whether any internal limitations have been placed on what is the usual authority of the person that you are dealing with. Then we get to something that falls outside of actual authority and apparent authority. This comes from the case of Watteau versus Fenwick, so it's usually referred to as Watteau versus Fenwick kind of authority. What happened in this case is that the plaintiff, Watteau, sold goods to a pub manager, Humble, under the belief that Humble was actually the owner of the pub. In other words, just take note here that Watteau was dealing with Humble, and Watteau thought that he was dealing with Humble and only Humble. He didn't know that there was anybody else in the picture. In both of the other cases that we've looked at here, the third party knew that there was somebody else in the picture. The third party knew that there was an agent and a principal, and the third party thought that I, as a third party, my contract is with the principal, not with the agent being the director, the managing director in Hilly Hutchinson and Freeman. Okay. However, it's different in Watteau, because in Watteau, Mr. Watteau thought that he was dealing with Mr. Humble. In actual fact, Humble was not the pub owner. And later on, it became apparent that the defendant, Fenwick, was the actual owner of the pub. Now, the actual owner of the pub, Fenwick, then sought to collect from Watteau the unpaid balance of goods that were purchased by Humble. And the question then was, this Humble, did he act on behalf of Fenwick as an agent? And the answer there lied in the following. An undisclosed principal, which we had here, can be held liable for the actions of an agent who is acting with authority that is reasonable for a person in the agent's position, regardless of whether or not the agent has the actual authority to do so. Now, here, Humble had entered into an agreement with Watteau, even though Humble did not have any authority to do so on behalf of the actual owner of the pub. In fact, the actual owner of the pub explicitly instructed Humble not to make any purchases outside of certain narrowly defined purchases. And this wasn't one of those narrowly defined purchases. Now, Watteau then discovered that Fenwick was the actual owner of the pub and brought an action. So the issue was whether there was liability resulting from an agreement between Watteau and Humble, where Humble knowingly acted outside of his actual authority as agent. And the court held that yes, there was liability. Humble was acting with an authority that was inherently reasonable for an agent in that position. The situation is analogous to a partnership, whereas one partner is silent but is still liable for the actions of the partnership as a whole. Now, why do we say this isn't either implied or apparent authority? Well, the reason is because the third party didn't know that there was an agency relationship, that there was a third party involved, the principal involved. So the decision could not be based on apparent authority, because when we're dealing with apparent authority, the principal is disclosed. The principal is right there in the picture. In actual fact, it's the principal who creates the impression that the agent can act on his behalf. In this instance, the claimant did not know that there even was a principal. Nevertheless, the principal is held liable for actions by an agent, even if they are expressly forbidden, if it was a situation where the third party was dealing with a person acting in a manner that we would expect this person to be able to act. In other words, where the actions of the agent were reasonable under the circumstances. Now remember, we've also got ratification, which is after the fact. You do something now on behalf of another person without their consent or permission, but afterwards you obtain that consent or permission. Ratification, therefore, is ex post facto granting of authority. Ex post facto means after the fact. One thing that you have to remember about, or have to know about ratification, is that you cannot act on behalf of a principal that doesn't yet exist. You can only act on behalf of a principal if that principal already exists at the time that you are doing the transaction on his or her or its behalf. This means that I cannot conclude a contract on behalf of a company that doesn't exist yet. I cannot say that I'm an agent of a company, and then once the company has come into existence, then ask the board of directors to ratify what I've done. I can only do that if the company already exists at the time that I'm concluding the contract on its behalf. Please take note here and go and have a look at pre-incorporation contracts and promoters of a contract, because this is very important. If you are planning on creating a company and you are concluding certain contracts in advance of this company being created, then those contracts will be in your own name. They cannot be in the name of the contract of the company that hasn't been created yet. This is a separate lecture, the lecture on promoters and company formation. Go and have a look at that. I'll put a link in the description below. Agency by operation of law. Finally, agency by necessity. This would be where you are for example, in control of somebody else's property, and you have to make certain decisions and you cannot get the owner's instructions. This would, for example, arise under an emergency. You are then allowed by law to act on behalf of the principal as if you have their permission, as long as you act in good faith. And agency by cohabitation, this is the other instance where the law assumes that or already gives permission for one person to act on behalf of another person without expressly having to get permission every single time. So this is why spouses can act on each other's behalf. The ways in which agency is created. The most important one is by authority, express or implied actual authority, or apparent or ostensible authority. Remember, apparent authority and implied actual authority very closely related to each other. And then also remember that there is Watteau's sphenic kind of authority, which falls outside of actual authority. Then we've got ratification and finally operation of law. Having looked at the ways in which agency is created, let's look at a few other things related to agency law, and very importantly. Now remember I told you that you have to understand and have to have very good knowledge of contract law in order to understand corporate law, company law, as well as agency. If you understand or have a good knowledge of contract law, then when you see the word warranty, it will already ring a bell for you because this is a term coming from contract law. In contracts, we've got terms and warranties, etc. So go and revise what is meant by a warranty. Now, a warranty of authority is a legally binding representation. A representation can become a term of a contract. A warranty of authority is a legally binding representation made by one person, the agent, to a third party that he, the agent, has the necessary authority to conclude this contract, and that he has the authority to act on behalf of another person. And then the third party relies on that representation. So what does this mean? It means that the third party has a contractual relationship now with the agent, and that contractual relationship has as one of its terms a warranty. And this warranty is a promise that the agent has the necessary authority to do what he or she is doing. And what does that mean? It means that if the agent did not have that necessary authority, he would be in breach of a warranty. And that would mean he's in breach of contract. So breach of warranty of authority. This is if the agent, it could be innocently, negligently, or fraudulently, either of those. If the agent made a representation to a third party that he or she had authority to act for another person, where in fact the agent did not have such authority, and the third party didn't know this or didn't have any reasonable grounds to know this, then it is a breach of warranty. And that means it's actionable in contract law. What can you sue for under breach of contract? Remember, you can sue for damages, etc. So a term in the relationship between the third party and the agent is this warranty of authority. And a breach of that warranty is seen as a breach of contract and it's enforceable. Let's just also look at the principal-agent relationship. The agent has certain duties. Number one is to obey the instructions of the principal. Remember, the principal is hiring the agent. The agent is working for the principal. So if you're working for somebody, you're employed by that person, you have to follow their instructions. The agent has the duty to exercise care, skill, and diligence, to perform their duties personally. In other words, unless you are allowed to do so, you're not allowed to delegate your duties. You have to do your duties personally. The agent also has certain fiduciary duties. Fiduciary duties are duties of good faith. So that word fiduciary, it comes from the Latin term bona fide. Bona fide means in good faith. So duties that you have to perform in good faith. These include avoiding a conflict of interest. So you cannot have a personal interest in something and your principal also has an interest in that same thing. If you have such a conflict of interest, you have to take yourself out of the equation, or you have to reveal that conflict of interest to your principal and have your principal decide what to do. The agent is also not allowed to make a secret profit or to take bribes. The agent has to account to the principal of what's been done, what's been spent, and the agent has a duty of confidentiality owed to the principal. Why is this important? Well, when we think about who is the primary agent on behalf of a company, it's the director. So if the director acts as an agent of the company, the director, we can expect, has certain duties owed to his principal or her principal, the company. And that is in actual fact the case. There's a number of cases, there's an area in company law focusing specifically on directors' duties. And when we look at directors' duties, you'll see it comes from this. It comes from the duties of an agent, just more specialized for directors. I'll put another link in the description for a separate lecture on directors' duties, as it is quite an important part of company law. So go and have a look at that lecture as well. What about the principal? Well, the principal also has certain duties. Number one, to pay what is owed to the agent. Also, to indemnify the agent for any loss or liability suffered as a result of the agency. So indemnification could be, for example, agreements on miles traveled, etc. The agent's remedies against the principal would include suing for breach of contract. So in other words, let's say that the principal does not pay the agreed commission. That would be a breach of contract, and the agent would could be able to sue for the damages, loss of commission. The agent could also set off anything that is owed to the agent versus anything that is owed to the principal. Example, let's say that the agent received certain monies from the third party, and that money was supposed to go to the principal, but let's say the principal owes the agent back pay. The agent could keep the money that was paid by the third party in lieu of the money that is owed by the principal. So let's say that the principal owes the agent £10 and the agent has received £5 from the third party. The agent can keep that £5 from the third party and subtract it from the £10 that the principal owes him. A lien is a legal right of retention. And this means that if you are in possession of something and the person who's the owner of that thing owes you a certain amount of money, you can keep the thing in your possession until the money is paid to you. It's a right of retention. So let's, for example, imagine that the agent has a company car, and this company car is worth £50,000. And let's say that the principal owes the agent £60,000 in commission, which the principal hasn't paid to the agent yet. In terms of a lien, the agent would be within his rights to keep that £50,000 car until the £60,000 has been paid, in which case he must then give the car back. So a lien is a right of retention. The principal's remedies. Number one, if the principal is not satisfied with what the agent is doing, the principal can always dismiss the agent. If the company is not satisfied with what a director is doing, the company can always terminate the director's contract, terminate his directorship or her directorship. The principal can also sue the agent. Now, this could be based on contract, This could be based on tort. We'll look at that in a second. Remember, the principal and the agent usually have a contract. This is where the agent's authority comes from. And that contract will tell us what can the agent do, but also what is the agent expected to do. So there might be a breach of contract if the agent doesn't do what he's supposed to do or exceeds the authority and causes a loss. But it could also be a tortious claim. Let's say that the agent is negligent. The principal might have a claim in negligence. If a director is negligent in the way in which the director does his work as a director, the company may very well have a claim against that director. And then if things are serious enough, if we're talking about fraud, then there might be criminal proceedings that arise. So the director of a company could very well face criminal prosecution if there's allegations of fraud. Finally, the third party. Remember, the whole aim of agency is for an agent to go out and negotiate on behalf of the principal in order to try and get third parties to conclude commercial contracts with the principal. So the end result would be a contractual relationship between the third party and the principal. Now we have to make a distinction here between the instances where the third party is well aware that they are dealing with an agent not directly in terms of getting a contract between those two parties, but they are well aware that the agent is acting on behalf of a principal. So the third party, right from the start, knows that in the end, my contract as a third party is going to be with the principal, not with the agent. I don't want to have a contract with the agent. I want to have a contract with the principal. I don't want to have a contract with the director. I want to have a contract with the company of this director. In this instance, we talk about the principal being disclosed. If the agent acted with the authority of the principal, easy peasy, then the principal is bound by contract to the third party and vice versa. If the agent acted without the authority of the principal, then the principal is not bound by the contract, but the agent is. And the agent, moreover, is in breach of his warranty or her warranty of authority to the third party. Remember, though, that the principal may ratify the contract. And also remember what we looked at when we looked at Watteau versus Fenwick. Because the third party could still hold the principal liable under those principles. So just be very careful when you see we've got, sorry, not Watteau versus Fenwick, implied actual authority. We now get to the situation where Watteau is actually important, and that is where we've got an undisclosed principal. Go back to the case of Watteau versus Fenwick. This was a situation where the third party didn't know that they were not dealing with a primary contracting party. So what happens then if the agent does not disclose that they are acting on behalf of a principal? The contract first takes effect between the agent and the third party. And it's only once the agent reveals that there is a principal that the third party then becomes liable to the principal. But what if the third party doesn't accept that? Then the third party has some recourse. We'll get to that. But let's first look at if the agent acted with the authority of the principal. So in other words, the principal knew that the agent was out there acting on his behalf, and the principal also knew that the agent was not disclosing that he was acting on behalf of a principal. Then the third party has a choice. The third party can choose to hold either the principal or the agent liable. So in actual fact, the third party can decide, I'm going to have a contract with the agent, or I'm going to have a contract with the principal. If the agent acted without the authority of the principal, as we had in the case of Watteau versus Fenwick, then the court will look at, well, what is the usual situation here? Would it have been reasonable for the third party to conclude a contract with the agent? There are three situations where the undisclosed principal cannot sue on the contract, even if the agent had actual authority. Now, this would be where the term of the contract excluded agency. And this would be a very good idea for you if you were the third party and you're a bit worried that I'm dealing with this person, but I think there might be somebody else in play. And I don't want to have any surprises. I want to deal only with you. You can make sure that in your contract that you conclude with this person, there's a term that expressly excludes agency. There's a term that states the parties to this contract is me and you, nobody else. Right? That would be a very canny move on your part. Refused to contract with the principal. So let's say that you've got some other objection. It could be a moral objection. It could be any kind of objection. Let's say that it's very clear that the principal is an arch enemy, and never in 1,000 years would you ever conclude a contract with him. Then the undisclosed principal cannot sue on a contract. Thirdly, if the third party only concluded the contract because they wanted to conclude the contract with the agent personally. So if there was something about this agent that was the reason for the contract, and you now find out that actually the agent was acting on behalf of somebody else. This would be, for example, the situation where, let's say you're a concert promoter and you get you contact Adele and you want Adele to perform. And Adele says, yes, sign on the dotted line. And then the time of the performance comes and she says, oh, here's my cousin, Janine. Janine is going to perform at the concert. I was acting as an agent on behalf of Janine. You as a concert promoter probably will not like this at all, because you wanted Adele, the singer, specifically to come to to perform this contract. The case of Xu Yongquan versus Eastern Insurance Company illustrates this. I'm not going to go into the facts of this case, but these three instances here gives us the summary of the law regarding undisclosed principals. So just to repeat again, the undisclosed principal can sue and be sued on a contract if the contract is made by an agent on his behalf, acting within the scope of his actual authority. The agent must intend to act on behalf of the principal, but the agent of an undisclosed principal may also be sued by the third party on the contract. Any defense that the third party may have against the agent is also available against the agent's principal. The terms of the contract may exclude the principal's right to sue or be sued. So the contract or surrounding circumstances may show that the agent is the true and only principal. For example, if the contract had a personal element, as we saw in this third example that I gave to you. So the relationship between the agent and the third party. Next up, we've looked at the relationship between the principal and the third party, where the principal was known to the third party and also where the principal was an undisclosed principal. Now let's look at the relationship between the agent and the third party. If the agent acted without authority by the principal, the third party can sue the agent for breach of warranty of authority. Now, this is a contractual claim. The third party can also sue for deceit. There's a tort called the tort of deceit, or for negligence if there was negligence, such as a negligent misstatement, which is also a tort that we get from the Misrepresentation Act. So both a contractual and a tortious element. Finally, how does an agency come to an end? How is an agency terminated? Firstly, the parties themselves can terminate the agency. First, if both parties have performed what they were supposed to perform in terms of the agency contract. For example, I get William H. Brown to sell my house. Once the sale goes through, I pay them commission. Then my relationship with William H. Brown as estate agent comes to an end. They performed, they sold my house, I performed, I paid them the commission. Or the term of the agency passed. Let's say I got William H. Brown to sell my house, and we agreed that they would be my agent for a period of a year. At the end of that year, if they haven't sold my house, the agency comes to an end. Or agreement. William H. Brown is trying to sell my house, and they take months and months and months and nothing happens. Then I could, for example, go to them and say, I don't think this is going to work. I'm going to take my house off of the market. Let's terminate the agency. And they agree to that. Remember, agency is a contract, and a contract can come to an end through agreement of the parties. A contract can come to an end when the parties have performed what they were supposed to perform in terms of the contract. But agency can also be terminated by revocation. If the principal revokes the authority given to the agent, the agency comes to an end. An agency can also come to an end automatically by operation of law. If the principal or the agent dies, that brings an end to the agency. If either of them becomes mentally incapable, such as, for example, through insanity, then the agency comes to an end. Death or insanity would terminate, of either the principal or the agent would terminate the agency. However, with bankruptcy, it's only the bankruptcy of the principal. If the principal becomes bankrupt, the agency comes to an end. Not so for the agent. So if you're a bankrupt agent, you can still work for somebody as an agent. Frustration. So in other words, if the purpose of the agency becomes impossible. So let's say that I get William H. Brown to sell my house, and there's an earthquake and my house gets destroyed. Then it's impossible for them to sell my house because the house does not exist anymore. That is frustration. Also, once again, a contractual term that you need to know, frustration. So you see how contract law, agency law, very important for you to know these things as they feed into and they underpin company law. And finally, an agency may be terminated under the Commercial Agents Regulation, which is a piece of legislation relating to commercial agents. So what is a commercial agent? A commercial agent is a self-employed intermediary who has a continuing authority to negotiate the sale of goods. So in other words, it's a sales agent. For sales agents, we've got a specific piece of legislation, the Commercial Agents Regulations. And this means that if you are a commercial agent, then you've got a little bit more protection, very akin to employment law. So, for example, commercial agents are entitled to minimum notice periods. They are entitled to compensation and indemnity payments, etc. So they've got more rights than the usual kind of agent. They treat it more like an employee as an agent. That brings us to the end of what you need to know in a nutshell about the law of agency in order to properly understand the principles of company law.